Mr. Lynds.
Thank you, Mr. Chair and committee members. As mentioned, my name is Grant Lynds. I'm the immediate past president of the Intellectual Property Institute of Canada. Thanks very much for inviting IPIC to present to you our initial thoughts on Bill C-86 and to answer any questions. As you may know, IPIC is the Canadian Professional Association of Patent Agents, Trademark Agents, and Lawyers Practicing in Intellectual Property. IPIC represents the views of Canadian IP professionals in many submissions to government and other bodies.
Grant, could I slow you down a notch? The folks in the booth here are having a hard time to keep up.
Nah, I guess I was just trying to make up time I didn't lose. IPIC represents the views of our IP professionals to many government submissions and other bodies. Our activities include a wide breadth of activities in education, continuing professional development, raising IP awareness in the business community. And for the past several years, we've even created a voluntary code of conduct for our members in order to belong as a member of our institute. Now, in the past few days since C-86 was tabled, we've had about 160 of our members looking at the provisions with the proposed changes to the Patent Act, the Trademark Act, and the Copyright Act. In that brief few days, we've been considering the wording, but will no doubt want to put in a written submission given the scope of the detailed proposed changes. There are a few examples that immediately hit our members, and I'd just like to touch on those. Some changes, one in particular, is a change for what's called known as file wrapper estoppel in the patent litigation field. And this was introduced by new Section 53.1 in the Patent Act, which is essentially the ability to introduce prosecution histories. This is the back and forth between the applicants for patents and the Patent Office into judicial proceedings. Now, this would change many years of our Canadian judicial precedent. This provision was introduced with little notice or debate and not mentioned as part of the national IP strategy. More specifically, though, our members felt that there is a lack of an appropriate transition period for this provision, especially with respect to active patent litigation, and the fact that existing patents that were prosecuted or obtained when this legal doctrine was not part of Canada's patent laws, but based on this new provision, the doctrine would apply immediately if and when these patents are enforced. Now, in hearing from our committees that looked at C-86 in the past few days, we can say most amendments are supported by IPIC in principle, but there are many areas when used in practice would create, in our view, unintended consequences. And I'll just summarize those. Some examples would include prior user rights in patents, a continuing lack of a requirement to show use of a trademark to obtain trademark registrations, and the statutory damages remedy for collective societies in the copyright, which appears to remove the availability of statutory damages in regard to sound recordings. We'll provide a detailed submission to the committee as soon as possible, identifying these potential issues. With that said, our priority in the remaining brief time we have is really to focus on some aspects of the bill that create the College of Patent and Trademark Agents. Now, as many of you know, we are happy to see this enabling legislation in C-86. IPIC has been advocating for the desire to have such a governing body for almost 23 years. And looking at the legislation, what I'd like to encapsulate really is two items that struck us that we'd like to raise as concerning issues. The first issue really relates to two provisions, Section 14C and D of the Enabling College legislation. So Section 14D, in effect, prevents IPIC members who have sat on one of our committees, one of our 37 committees, in the preceding 12 months from being eligible to sit on the college's board of directors or other important committees of the future college. It would also exclude those who have been volunteers of other organizations representing our profession in Canada and internationally. Now, IPIC, we've got a great membership as far as volunteers. We have more than 400 volunteers sitting on our committees, which is about 1/4 of our membership. These are the profession's most engaged members and often the most senior, most knowledgeable people of the profession. Taking into account that these would be excluded, our view says that after that exclusion, you're really left with an extremely small pool of candidates who have the necessary experience and knowledge to sit on the college board. As an example, we have many committees that deal with professional development. We have members that deal with the federal court in regard to changes in federal court litigation. We have public awareness committees One is actively advising on Indigenous IP issues. All of these members, based on this provision, if they had sat on these committees in the preceding 12 months, would be excluded from the leadership, the board positions of the college. We believe this rule is unnecessary, or this provision is unnecessary. It's also inconsistent with other professions. For example, the Law Society of Ontario does not have such a restriction on its board members, its benchers, and in fact, they encourage the members to be actively involved in voluntary associations. So in our view, the emphasis should be to repeal Section 14D and C. 14C would actually make a member of IPIC ineligible for the board based on membership alone. Our view is the legislation should not prevent the college from having the best chance possible to succeed. The college should have the most qualified pool of candidates available for its leadership. And the second and final issue I'll highlight in our remaining time pertains to Section 33, Sub 1 of the college legislation that requires the inclusion of a code of conduct in the regulations. The code of conduct should be a living, breathing document, and there's a rapid pace of involvement or evolving change in both business and the IP profession. And we believe it is very problematic for the code to be part of a regulation. The code is often written into the bylaws, or it's a reference by regulations, but it should live outside the regulations. We recognize that the code may be deemed to be a regulation under the Statutory Instruments Act, but allowing it to exist as a bylaw or some form outside the regulations gives the college the ability, the flexibility to be nimble, to amend the code efficiently, and react as a one-stop organization as a guardian of the public interest. To give an example again, looking at the Law Society of Ontario, the code of conduct for them is called the Rules of Professional Conduct, which are not embodied in the regulations under the Law Society Act. The benchers or the Law Society Board oversees and approves the Rule of Professional Conduct, but the rules are not the actual regulations under the Act. The authority to make the rules and bylaws comes from the Law Society Act by way of legislative delegation. And our view that there
Grant, you're starting to pick up speed again, I'm told, but and you are going to have to finish up. We're considerably over time here as well. Go ahead.
Absolutely. Thank you, Mr. Chair. I'm just going to wrap up and say, in many cases, the code is created through bylaws, and there are already several provisions in the legislation that provide for very strong oversight by the minister, such as the majority of public seats on the college's board appointed by the minister, the ability to remove a director for any reason, and even to require the board to do anything the minister feels is necessary. In our view, the best place for the code is not part of the regulations, and that would give the college the best ability to react, be the safeguard of public interest, and have the flexibility to revise the code and treat the code as a living document for all of the members and the public. Thank you.
Thank you, Mr. Lyons. Then turning to